Good morning, Ms. Johnson.
Good morning again, Your Honor. This is on the appeal of the finding of contempt by Justice Spina. Again, I'll read. It's just a few minutes again, same 5 minutes. The judgment of contempt and my subsequent imprisonment was more a punishment of my clients because they had me as a lawyer than a punishment against me, although it was that too. By denying my motion to stay the order to withdraw from my clients' cases, the single justice both deprived my clients of their right to have counsel of their choice and interfered with the orderly prosecution of their cases. The judge never considered the immediate and irreparable harm and damage as this order would cause my clients. The full court, this panel, did similarly when the clerk of the court on this court's behalf, so I've been told, summarily denied the motion to stay I filed here. Upon learning of the denial, I reasonably concluded that the judgment of disbarment was predetermined and that the single justice too knew that. For were this court neutral and the option to reverse Judge Spina's decision still open, Judge Spina would have allowed me to continue, at the very least, to represent my then existing clients. That didn't happen. Each of my clients' cases was about to be horribly and needlessly prejudiced. At that point, I was less upset about my own disbarred status than I was for clients. Their cases were generally complex and at stages which made it unlikely that another lawyer could be effective. My clients would be left without their counsel of choice when they most needed counsel familiar with their cases. My duty to them and to their cases was my responsibility and had top priority. I thought the court would understand and would not exalt procedure over substance. And I was unwilling to defy justice by sacrificing substance for procedure. During the next 30 days, between the judgment of disbarment and the date it became effective, I had been working to tie up as many loose ends in my cases as possible. The disbarment was effective on September 8th, a Friday. Prior to that date, 2 of my clients had been ordered to court on the following Monday and Tuesday. Without adequate opportunity to find substitute counsel, my clients would be at a loss were I not there. So in one court, I appeared really to deliver what I had previously been ordered prior to the disbarment to write and deliver on that Monday. And in the second court, I appeared to inform the judge of my idea for a reasonable settlement, as well as to inform him that I had not heard from this court as yet regarding my motion to stay. I had not received that yet. Those appearances prompted the Assistant Bar Counsel, Susan Strauss-Weisberg, to add an allegation of the unauthorized practice of law to the complaint for contempt that she filed in the single justice session. At that hearing, I attempted to show that where an order had no pretense of validity when it issued, it is transparently invalid and cannot form the basis of a contempt citation. Nevertheless, because I had failed to withdraw from any cases as the judge had ordered, he found me in contempt and imprisoned me to force my compliance. Nothing that Judge Spina wanted me to do, however, could be done from prison. I didn't hold the key to my cell door. I was just simply being punished. The contempt was thus criminal in nature, with the possibility of indefinite incarceration, and but for having friends, a few human angels, I would still be imprisoned. That gave me an entitlement to a jury trial for which I asked but was denied. Further, where I didn't hold the key to my cell door and the contempt charge brought against me was de facto criminal in nature, the county court had no jurisdiction either to hear or to sentence me to any incarceration, definite or indefinite. Judge Spina did not declare it a criminal contempt because currently there is no statute or case law addressing the issue of incarceration for criminal contempt in the single justice session. He would have had to treat me disparately and thus violate my right to equal protection. The denial of equal protection is unfortunately done in our courts daily. For instance, a defendant being tried for criminal contempt in family court is denied a jury trial, but a defendant being tried for criminal contempt in superior court is afforded a jury trial. Where the single justice acted intentionally and knowingly to deprive me of my constitutional rights, the judge was no longer acting as a judge, but to quote Pearson v. Ray, but as a minister of his own prejudices. In sum, where I did appeal the judgment of disbarment on the grounds that it was transparently invalid or had only a frivolous pretense to validity, I could ignore the order until the appeal was resolved, and the appeal is still not resolved even as of today, of course. Therefore, the order issuing simultaneously with the disbarment judgment was void ab initio. The finding of contempt was a clear error of law requiring reversal. The resulting incarceration was an egregious abuse of discretion and a clear error of law. Where I was deprived of equal protection, the judge not only deprived me of the benefit of appealing the disbarment to the full panel of this court, it gives the appearance that the right to appeal his judgment is but a sham. The practice of law is allegedly a learned profession, is a fundamental right. To have deliberately, recklessly, with callous indifference deprived me of my fundamental right to property and subsequently my liberty, before I had the benefit of an appeal, as other members of the populace have, Judge Spina had violated both Section 2 of Article 4 and the 14th Amendment of the United States Constitution. I rest on my brief that Judge Spina's implicit or inferential finding that I was practicing law by my appearance in court one business day after the disbarment order became effective, I call it Axe Day, was clear error. A criminal charge must have elements so as not to be vague or overbroad. If the practice of law cannot be defined, neither can the unauthorized practice of law, making sections 41, 46A, 46B, 46C unconstitutionally vague. Thank you, Your Honors.
Thank you, Ms. Johnston. Ms. Weisberg?
Members of the court, as has been so amply demonstrated, the fundamental, in Bar Counsel's view, reason for the contempt proceeding was that Ms. Johnson is of the opinion that if she does not agree with an order of this court, she does not have to obey it. The contempt was imposed upon sustained findings of Ms. Johnson's clear and undoubted disobedience of a clear order of this court. The integrity of the court requires the upholding and finality of judgments. All members of the bar must recognize and hew to the principle of finality of judgments for the reasons stated in our combined brief. And again, unless the panel has any questions, Bar Counsel rests on the brief.
Could you just say something about the difference between civil and criminal contempt?
Yes. First of all, the contempt proceeding was brought as a civil contempt. Civil contempt is intended to coerce, a proceeding for civil contempt is intended to coerce a non-compliant litigant's compliance with an existing order. Criminal contempt is intended to punish a litigant for disobedience of an order. And I have cited a case in my brief, I believe it is the Marvin Gardens case, that says that where one indicium of whether a contempt is civil or criminal, other than labeling it as such, is whether or not the remedy sought is coercive or punitive. And incarceration to coerce compliance is a classic civil contempt remedy as opposed to incarceration for a definite term or imposition of a fine. One, I believe, of the articulate concerns here as to the distinction between the two is that there is support, there is entitlement, or at least a claimed entitlement to a jury trial in cases of criminal contempt, but not in civil contempt. And I believe that's what's underlying that issue.
Thank you, Ms. Weisberg.
Thank you.